asking you where is the source of power for that particular authority. Suppose we are exercising writ of mandamus under Article 226. There is a provision for issuance of writ of mandamus.
Under Article 162.
Huh?
Under Article.
All right, we will deal that.
There cannot be beyond any other power.
Yes.
And for the Employment Committee Chairman, they have exercised power on 162. That the scale of pay will be of Chief Secretary. Court has decided. And therefore, these are the operation. My Lord will consider, after so much period, still I am not getting my share. If I am asked to go to civil court, firstly it will be barred by limitation, firstly. And secondly, my Lord, how many years?
No, even approaching this court, it is a barred by limitation. Because your cause of action occurred in 2004. At the best, you should have approached this court in 2007. But after 1 decade, you are approached.
Because this was my salary was depending on Annexure 6, which was in 2004. So unless the first issue is decided, salary of chairman, that has been decided in 2016.
Yes.
Therefore, we not.
So it is not learn senior next at this stage, learn senior counsel. So and so vehemently contended that source of power for appointment and assignment of remuneration to the post of chairman, monitoring committee, ManisanaWage board is under Article 162. Annexure A6 to the rejoinder cited supra is required to be read with reference to Article 162. No, it should be 166. State power is 166. 162 is central government. 166. 166 of the Constitution. Full stop. He has also submitted that appellant, he himself, while holding the post of Chairman, State Employment Committee, he was not paid the remuneration. Therefore, he has invoked remedy before this court, and it was he had been extended remuneration on par with a particular post in the state government. The same was confirmed by the division bench and apex court. Next one. At this stage, it is necessary to notice the ultimate grievance of the petitioner appellant is that he is seeking for a writ of mandamus for issuance of a direction to the respondents to pay the remuneration in terms of Annexure 6 cited supra. This court has already noticed that Annexure 6 is not a final outcome like issuance of notification under Article 166. Notification/executive order under Article 166. Apex Court, a decision cited supra. Suffice that appellant has no statutory or vested right in respect of incomplete proceedings of the state government in assigning remuneration to the post of chairman, monitoring committee, ManisanaWage board, unless and until appellant establishes his legal or a statutory right under a particular provision of law. He has no vested right to seek a writ of mandamus to pay certain remuneration or consolidated pay. Insofar as extending remuneration to the post of chairman, State Employment Committee is concerned, we are not aware what is the source of power and how it has been created with the state government. For issuance of writ of mandamus, the aforesaid ingredient is mandatory as held by the Apex Court in the case of Mani Subrata Jain versus State of Haryana, reported in so and so, para so and so. In the light of the aforesaid principle, which has been reiterated by the Apex Court in the case of so and so, the appellant has no vested right to seek a direction in the absence of a vested statutory right with him. Next paragraph. The action of the respondent in appointing appellant to the post of chairman, monitoring committee, ManisanaWage board is without source of power. In other words, arbitrarily exercising power and appointing a particular person without resorting to Article 14 and 16 of the Constitution is wholly illegal. Even to this day, they have not withdrawn, cancelled or modified. Such arrangement of appointing appellant to the post of chairman, monitoring committee, ManisanaWage board is continued from 2004, 28/8/2004. The appellant for the first time approached this court in the year 2017 seeking remuneration. The entire exercise of the official respondent is without any source of power, like how the ManisanaWage board has been created under the state, like under a particular statute or an act, staff of the board, method of appointment and other service conditions of the staff of the ManisanaWage board has not been determined in the manner known to the law. Therefore, each and every action of the respondent is in violation of most of the constitutional provisions. Apex Court in the case of D.A. Wadhwa, within bracket Doctor versus State of Bihar, in respect of violation of rule of law, it is held as under. Next paragraph. Even after 75 years of independence, state government has not adhering to the constitutional provisions insofar as filling up of public post like the present, like chairman, monitoring committee, ManisanaWage board. Apex Court in the case of Tees Hazari Court versus Renu and others, wherein it is crystal clearly held that if in order to fill up any public post, the competent authority was required to follow the relevant constitutional provision like Article 14, 16, 309, 166, 162, etc. Full stop. In the present case, the aforesaid provision has not been taken note of before effecting order of appointment to the appellant to the post of chairman, monitoring committee, ManisanaWage board. Full stop. Further, state has not taken note of that as on the date of appointment of appellant to the aforesaid post, he was already holding the post of chairman, state employment committee. In such an event, whether a person can hold dual post in the state organization or state undertaking institution or not. In other words, prima facie, in order to accommodate a post to the appellant, the state government has exercised power of appointment in the absence of any statute or a source of power. In view of these facts and circumstances, it is a case for imposition of exemplary cost on the state for having wasted the manpower of the appellant, and this court cost is quantified at rupees 10 lakhs. Cost shall be remitted in the Prime Minister's Relief Fund within a period of 3 months. The Chief Secretary, the learned Chief Secretary of the State of Bihar is hereby directed to take note of the present case and circulate the same among all heads of the department, all the secretariat and heads of the department, so as to enable them to invoke constitutional provision wherever it is warranted. Accordingly, the Land Council for the appellant has not made out a case so as to interfere with the single judge order, and LPA stand dismissed.